How a failure to undergo neuropsychological testing dooms a brain hemorrhage disability insurance claim. A disability policyholder or plan beneficiary has the burden to prove that they are disabled under the applicable terms of a disability insurance policy or plan. Now, that proof often takes the form of medical evidence, and without it, your disability insurance claim most likely is going to be denied. Often, courts will defer to the disability carrier or plan's denial of a claim when the medical evidence is lacking or the policyholder or plan beneficiary doesn't undergo recommended testing that will document the nature of their problems or the extent of their restrictions and limitations. And that's particularly true if the testing is non-invasive. That's what happened in the case of Phillips versus Aetna Life. Now, Phillips unfortunately had been assaulted and sustained a subdural hematoma and an intraventricular hemorrhage in the brain. These injuries left him with cognitive problems and memory impairments. Those problems made it impossible for him to return to his job as a systems engineer for Boeing. His claim for his own occupational benefits was denied, and ultimately he filed a lawsuit. The federal court noted that Phillips' own treating doctors opined that he could return to work. There were updated CT scans that showed a complete resolution of the subdural hematoma and the hemorrhage. However, he continued to have cognitive problems and memory impairments. To prove the extent and nature of those problems, Aetna asked him to undergo neurocognitive testing, which is non-invasive. It does take several days. Normally it's a 2-day testing affair. And the court noted that even Phillips' doctors recommended the testing, but he never took the testing. That testing could have proved his impairments, and as a result, his claim was denied. Now, the judge was not impressed and upheld the claim's denial. He found that Aetna had examined all the evidence that was in the file and properly determined that Phillips was not entitled to his benefits based on what was in the file. Now, Phillips didn't meet his burden of proof, which I think he could have done if he just underwent the testing. Now, in addition to undergoing the testing, there should have been a vocational evaluation that would have tied together the results of the neuropsychological testing to confirm that he was in fact having memory problems or cognitive problems that would interfere with his ability to do the material and substantial duties of his occupation. So it was a matter not only of medical proof, but of vocational proof. You've got the burden of proof. My job as a disability attorney is to examine the strength of your medical records and whether or not you have testing and whether or not that testing is sufficient to support the claim, or whether or not we need to get vocational evidence to tie all of the parts of your disability claims together. I'm not afraid to take on disability carriers across the nation, and I'm not afraid to take on wrongful denials or terminations. But you can see it takes a team to get disability benefits. Call me today at 727-894-3188 for a complimentary consultation. I look forward to helping you regardless of where you live in the United States.